Hey, this is Ryan Witt, defense attorney here in Washington State. This video is about whether or not a person has to use their court-ordered public defender. And the short answer is no, you don't. We get these calls not right after the arraignment. It's usually after a couple months have gone by. Maybe that individual has emailed their public defender a few times. They've left 5 or 8 voicemails. None of those messages have been returned. So they'll call us and kind of apprehensively be like, I don't know if I can switch because the court gave me an order saying I have to contact my public defender. Now, what's happened, if you kind of rewind this, when a person is arraigned and they're in custody, the court does give them an order saying you have to contact your public defender. And I think that's where this misunderstanding is coming from. But that is not accurate. You can, if you're still in jail, you can hire private defense, or when you get out, you can hire anyone you want to help you with your case. Now, the problem, we always like taking these cases on and trying to get them going back in the right direction. But the problem is, after a person calls us 2 or 3 months down the road and they want us to kind of bring things back and salvage it, public defenders don't have the same requirements. They have to do things when there's a person's liberty interest at stake. So they don't have to be looking into issues with Department of Licensing or other collateral consequences. So honestly, a lot of timelines just blow right by, and that person has never been advised. So we do what we can when we come on several months later, but I always like to get the word out. You don't need to wait that long. I mean, jump on board right away, because we can often create a path right at the time of the arraignment or even before, where it's going to be a kind of more of a roadmap to success. I was saying people wait a couple months before they call. They realize something's happening. I think the reason they don't call and want to swap is it's one of two things. Either A, the court ordered them to contact the public defender, so they just don't think they can deviate and go another route. Or B, they're honestly, it's like a breakup. You don't want to make that awkward phone call. You don't want to have that weirdness of, oh, I'm going to choose another person. So they're more like just anxious about doing it. Number one, you can swap at any time. And number two, there is no, anxiety producing phone call. There's no breakup you have to do. Like if you hire us or anyone else in the private sector, we do all that for you. It's really just volleying of paperwork back and forth, and we substitute in for public defenders all the time. So it's not really an awkward, situation that you have to go through. So hopefully you're not watching this 2 months out and making this decision right now, like, man, should I drop my public defender and go another route? Hopefully you're within days of your arraignment, so we can still get in and kind of get a roadmap to success for you here. So if you have any questions about public defense or swapping over or even bail, certainly give our office a call. We are, again, in Kitsap County, Washington. Thank you.